G'day everybody, and welcome to this, the final week in Laws 12063, Advanced Statutory Interpretation and Drafting. I'm Anthony Marinac. This week we're going to round out our course by examining two final areas of non-statutory drafting. We're going to look at drafting wills and also at drafting contracts. Again, the purpose for this week, just as with the purpose for last week's lecture, is to show that the techniques of drafting and the techniques of interpretation that we've been looking at right through this semester, whilst we've taken a statutory approach, they go well beyond statute and they can be useful to you in all of the areas of drafting within your practice. What we're going to do today is look at how we plan, draft and execute a will, how we plan, draft and execute a contract, and we're going to look at some of the general rules around wills and contracts. Now, of course, all of you will have studied contracts earlier in your degree, and so from that perspective I can presume that all of you have a reasonable working understanding of contracts, although I do recognise that for some of you it may be a subject that was in the dim dark past by now. Some of you will also have done succession law, and so you'll be familiar with wills. Others of you will not have done succession law, and so wills may be something completely new to you. Can I please get you to understand very clearly before we go any further in this lecture that the purpose of today's lecture is to talk about drafting technique. It doesn't matter how good your drafting technique is if you don't also have the knowledge of substantive law to back it up. I'm not going to be able to teach you in the space of half of a lecture the fundamentals even of succession law. If you haven't done succession, then treat this just as a drafting exercise. Please understand that simply doing this week's lecture is not going to put you in the position where you could effectively draft a valid will which you would be happy for somebody to go ahead with, thinking that they had made the appropriate arrangements for their family. Please don't draft a will until you've done study of succession law, and I would say for your first few wills at least, take the time to work with a more senior solicitor so that you know that you're doing the job properly. Having said that, we will look this week at some basic skills. So let's start, shall we? What is a will? Most people, even if they haven't studied succession law, have a pretty general idea about what a will is. The law regards the idea of possession and ownership quite jealously. Possession and ownership are pretty central to our idea of economics and also to our culture. Within the way that our society works, things are able to be owned. People are able to have private possessions, things that are theirs. Now, of course, there's no reason necessarily why this should be so. It would be quite possible to conceive of a society where nobody owned anything, where everything was equally shared by everyone. Some people would regard that as utopian, some people would regard that as dystopian, but in any event, it's certainly possible to consider that such a culture might exist. Because our culture regards possession and ownership as important things, our culture recognizes that when somebody owns things at the time of their death, they may still wish to have a say in where those things end up, in who takes ownership of them when a dying person relinquishes ownership of them. Most people who die leaving behind family members will, for instance, want to make sure that those family members are cared for from the assets that a person has developed during their life. The thing is, of course, that by the time a person has died, they no longer have a legal personality and they no longer have the ability to instruct the courts as to what should happen with their stuff. The other thing, of course, is that sometimes death comes along unpredictably, and so we can't simply have arrangements for the transmission of goods at the end of life, assuming that the end of life is going to happen in any sort of a predictable way or at any sort of a predictable time. The solution that the law has developed is a will. A will is a document that is prepared by a person, we call that person the testator, and it gives instructions to another person, who we call the executor, as to how the testator's estate, that is, all their stuff, should be distributed after they die. These instructions will be given effect by the court, even though the person who made those instructions, the testator, is no longer alive and therefore no longer has a legal personality at the time of execution. So a will is really the person's last opportunity to have any say at all about what happens to those things which they have taken ownership or possession of during their life. For many people, a will goes beyond merely being a document about things. For many people, a will is a duty, a matter of looking after those that they love, and for many people, a will is also a matter of high emotional stakes. Many people see a will as something that is their last opportunity to be heard on the earth, particularly where people have a range of heirlooms or a range of items that have emotional or sentimental significance. The making of a will and the dispersal of those items of emotional significance can be a very challenging process for your client. Making a will, particularly with someone who may be contemplating their death, can be a very challenging time for a lawyer and often requires great sensitivity. It's therefore a pity that for many lawyers, making a will eventually becomes a routine practice, something that they do with great professional skill, but it becomes very much a normal part of a workaday life. I would encourage you, when you're making wills, to always bear in mind that you're doing something that's particularly significant to your client. So what are the things we should be thinking about? Well, the first thing we need to do is identify the testator. Now, you would generally think that that's going to be pretty simple, and most of the time it is. However, there are some times when identifying the testator can be more challenging. For instance, what happens if a person who's getting on in years and who's starting to become frail is essentially marched into your office by a son or a daughter or some other relative, and that son or daughter or other relative says to you, "Mum or Dad wants to make a new will"? Who's the testator? Well, the testator is the person who wants to make a new will, but they might not have expressed to you themselves that they do want to make a will. What if you sit them down and you start asking for instructions for this will, but all of a sudden it's the son or daughter doing all of the talking? Are you really taking instructions from the testator in that situation? It's really important when you're making a will that you work out who the testator is and that you fully assure yourself that the instructions you are taking are the instructions of that testator. The second thing you need to work out is whether the testator has the capacity to make a will. That is, are they of a sufficient age to make a will? Are they 18 years of age? Do they have the legal competence to make a will? Are they able to understand the nature of a will? Are they able to communicate to you sensibly their intentions? Do you have any reason to believe that they may be under duress, or that they may be sufficiently mentally disordered at this point in time that you're not confident that the instructions that they are giving you are instructions that you should be putting into effect? If you're not certain about the testamentary capacity of a person, then it's best not to make a will. The third thing you should confirm is that they understand the nature of a will. Most people who come to see you to have a will made will understand the nature of a will, but strangely not everybody does. Some folks may believe, for instance, that as soon as they sign their will, the beneficiaries under that will have some sort of a claim on that property even during their life. Other people will believe that wills do things that wills almost never do. For instance, it's very uncommon for a will to govern superannuation, because normally on a person's death, superannuation payments are made directly from the superannuation company to a beneficiary. The same can be said of life insurance. Another common one that I've had with people for whom I've written wills in the past is that people will try to write in to their will instructions as to what should happen with their remains in terms of them becoming organ donors. Now, of course, by the time somebody gets their hands on the will and starts thinking about executing the will, it's going to be much too late for organ donation to be viable. So make sure the person who you're making a will for actually understands the nature of the document, understands what it can do, and understands what it can't do. Finally, think about whether they may be subject to any improper influence. Let them talk for a little bit about why they're making a will. Let them talk about the people who may be beneficiaries under the will. It's surprising how often, particularly when a testator is getting on in years, that they may be manipulated by family members into making a will which is not their own. Remember that ultimately you, as the legal practitioner, are responsible to your client for giving them the best advice that you can. If somebody seems to be making a will under any sort of duress, ask yourself professionally, should I be making this will? Once you've got all of those questions out of the way, you can start to look more carefully at the components of the will itself. If you look on the PowerPoint slides, you'll see on the fifth PowerPoint slide and also in the notes, I've indicated a series of steps that one ought to go through to write a will. The first thing to do is to identify the testator. Generally speaking, the testator will identify themselves by giving more than just their name. It's not actually that uncommon these days for people to share a name, and so simply identifying oneself by one's name may not be enough. I encourage testators to give name, date of birth, address, and quite often also their occupation. Now, of course, their address may change over time, and it's really not necessary for them to modify their will every time they change address. As long as it can be shown that at the time the will was executed, they resided at that address, it's pretty clear whose will we're talking about. The very next thing that a will should do is revoke any previous testamentary instruments that have been made. That is, any wills, codicils, or any other types of testamentary instrument that a person may have executed in the past. Sweep them all away and start again afresh. The third thing a will should do is nominate executors. The executor is the person who takes the will and puts it into effect after the death of the testator. So the executor is the person who's going to seek, for instance, probate on the will. So they're going to be the ones going to the court to apply for authority to act on behalf of the testator's estate. The executor should be somebody who's sensible, somebody who is going to be able and willing to do the sort of work involved in executing an estate. If you can find someone who's done it before, that's great. A lot of solicitors also encourage clients to nominate them as the executors. I generally recommend that testators have at least 2 executors, so that if one executor becomes unwilling or unable to act as the executor, the other one can step in. The next thing to do is identify the estate. You need to be really clear about what the estate of the person actually is. You'll find that most firms have instruction sheets set up to assist you to work out what the estate of the person will be. In many cases, we might be talking about a house or other significant real assets. We may also be talking about choses in action, such as shares or ownership of debt. We may be talking about money in bank accounts. We may be talking about significant personal assets. Make sure before you proceed to any further that you have a very clear idea of what the estate is. Take a great deal of time, ask a lot of questions, make sure that you fully understand what it is that your client has that is now going to be distributed. Once you've done this, ask them in general terms. What do they want to happen? What do you want to happen with your stuff? Get them to tell you in plain language, and once they've told you in plain language, use your skill as a drafter to start to identify what should happen. Generally speaking, most wills will deal with what are called specific gifts first, if there are specific gifts. A specific gift is where an item, such as an heirloom, is given to a specific person. Specific gifts can be very legally problematic. Take them very seriously. If you don't know what you're doing, ask. But generally speaking, specific gifts are likely to be dealt with first. The rest of the estate may be distributed in a number of ways. It may be distributed according to shares. It may all go to one specific person. It may go to a range of people in different amounts. Work out the scheme of distribution and then nominate it as simply as you possibly can. After you've established the scheme of distribution, the next thing to do is to work out what's called the residuary distribution. This is your final backstop. Who's going to get the stuff if the people who it is intended to give things to under the initial scheme of distribution are not able to take those gifts? If, for instance, they die before or at the same time as the testator, or if for some other reason they're unable or unwilling to take their gifts, what's going to happen to the rest of the estate? It is not good practice to write a will which doesn't have at least a couple of layers of backstop. You don't want to write a will and later on find that because you hadn't structured enough residuary protection for the testator, they find that certain gifts fall through on the first round and there's been nobody nominated to take those gifts in that event. If nothing else, you're going to leave the executor then in a position where they have to administer part of the estate as being what's called an intestate estate, that is, an estate which is not subject to a will, and that's going to make things very complicated very quickly. Once you've completed the residuary distribution provisions, you've pretty much completed the necessary elements of the will. Many people also include in their will funerary instructions. Now, those funerary instructions are just a wish. They're not a binding instruction, but the will it makes a great deal of sense in a will to be indicating what somebody wishes to have happen with their remains after they die. Finally, at the very end of the will, we have what's called the testimonium. The testimonium is the formal set of words which enables the signature of the person making the will and two witnesses. Now, executing a will is complicated. It's really important to get it right. I'm going to describe it briefly here, but let me go back to the warning that I gave at the start. Listening to this short lecture doesn't make you an expert in writing wills. Executing wills needs to be done properly and it needs to be done carefully, and you really should study succession law before you have a go. The way it works is that the will has to be signed by the testator, and it has to be signed by at least two witnesses, and all of the witnesses and the testator have to be in the same room at the same time so that they can witness one another's signatures. So the witnesses are not just witnessing the testator's signature, they're also witnessing one another's signatures. It is good practice to have the testator and the witnesses use the one pen, preferably a blue pen, so that the court can very clearly see, by the fact that it's all the same ink, they can very clearly see that everybody was likely to be in the same room at the same time. final thing to be aware of in terms of executing a will is that neither of the witnesses can be a person obtaining a benefit under the will. So a beneficiary under the will cannot execute the will. They cannot be a witness to the will. And you can see why, because a person who is witnessing the will has obviously got a conflict of interest if they are also a beneficiary under the will. Now that's a very brief gallop through, in general terms, for a will. There is a set of instructions, an extra normal animation, so that you can have a crack at writing a simple will yourself. Approach this just as a drafting exercise, not as a statute law exercise, but do have a go. Finally, we're going to move to contracts. Now you've all done contracts, contract law. You're all aware of the elements of a contract. You're all aware of the elements of contract formation, capacity, promise, consideration, intention to form contractual relations. I'm not going to go through all of that stuff because it should be very familiar to you from first year law. Instead, we're going to press straight on with some basic structure of what a contract would look like and how you would draft one. The first thing that you're going to have to do for any contract, obviously, is identify the parties. Identifying the parties is really important, not only for questions of privity, but also because we're hoping that most contracts, if you've drafted a contract well, you're hoping that it's never going to come anywhere near a court, because you're hoping that it's going to settle the relations between the parties in a way that doesn't require anybody to go back to court. Setting out just who the parties are can be really important, particularly where somebody may have several personalities. And what I mean by that is somebody may be contracting as an individual, they may be contracting as a member of a partnership, they may be contracting as an officer of a body corporate. So it is really important to make sure we know exactly who or what is a party to the contract. So the first thing the contract should do is set out and clearly identify those parties. The second thing I think a contract should do is identify the promise. Now, we're obviously talking here about very simple contracts, but that's fine. We've said that all along. A very simple contract will probably only involve one promise and one type of consideration. So it might be, for instance, I am going to paint your house. I agree to paint your house. Now, of course, a promise is never that simple, and you can see in the lecture notes for this week that I've said, well, maybe there's some additional details we need to put in. The address of the house, whether we're just talking about the house or any outbuildings. Is it just the basic house to be painted, or additional things like the downpipes and guttering? Is it to be painted a specific colour? Are they meant to use a specific brand or type of paint? Is it meant to be done by a certain day? Are there any of the other jobs around painting, like stripping and applying undercoats, that are also regarded as part of painting the house? Why are you going into so much detail? Well, it's really important to go into that level of detail, because that level of detail will tell the parties how the contract can be discharged by performance, and when the contract will be breached. Once we know what the promise is, we can tell whether the promise is being kept or not. So it's very important when drafting a contract to identify the promise and then start asking questions until you're satisfied that you've got sufficient detail about it. The third thing to identify is the consideration. So what is the promisee going to provide in return? Are they going to pay a sum of money? Are they going to perform some service? Are they going to refrain from doing something? What is the consideration that is going to be expended in order to purchase the promise? Once we've set out the promise and the consideration, we need to start thinking about discharge and breach. How will we know if the promise is kept How will we know if the promise is not kept? What are the performance metrics that are going to apply to this promise? Have we set out the promise in enough terms, in sufficient terms, that it is going to be clearly unambiguous to anyone who looks to work out whether or not the promise has been given effect? Now, this can take a great deal of work to get right, but you have to do it, because otherwise the contract is not going to end up being worth the paper it's written on. This is where we challenge ourselves to use specific language. If we think about our principles of plain English, we need to have a contract that is clear, but we need to have a contract that is sufficiently comprehensive, that it does everything that the contract needs to do. Writing this sort of thing is going to challenge your skills as a legal writer. Once we've set it out in enough detail, we then need to say what happens in the event of a breach. Have the parties worked out what penalties are going to apply in the event that the contract doesn't go ahead? Are those penalties reasonable within contract law? Are those penalties liquidated, or is there something else that is going to apply? Who gets to decide? What mechanism is going to apply to enable those penalties to occur, or to enable those consequences to follow? The next thing to think about is the allocation of risks. There are always risks associated with any contract. How are those risks to be shared between the parties? Have the parties even thought about this? Do you need to be sitting down with the parties to discuss what risks may arise from the performance of a contract and how those risks are going to be shared? Once you've worked your way through all of these, you can then get to the point of executing the contract. Now, strangely enough, execution of a contract is much easier than the execution of a will. There are various ways that you can demonstrate that a contract has been given effect. If you think about a unilateral contract, the contract may actually be formed by the performance of whatever's required under the contract. So there may never be a signature at all. If you think about the contract established by yourself and, say, a car parking centre, the contract is established by you driving your car past the boom gate. Contracts are formed in all sorts of ways, from the very informal to the very formal. If you're drafting a contract for clients, then at the very least, I suggest that the contract include a testimonium clause that says that makes it clear that the parties are engaging in a contract which is intended to create binding relations between them, and signatures which are witnessed on both sides. There's a couple of additional rules we need to think about with contract law, and these are rules that are very specific to us as drafters. The first rule is that contracts are void if the provisions are not sufficiently certain. Now, provisions don't always have to be certain in the sense that sometimes things are not known at the time that you're drafting the contract, but in that case there has to be a means for establishing those provisions with certainty. If provisions in the contract are not written with sufficient certainty, if they are not sufficiently comprehensive in terms of our plain English drafting, the contract may end up not being justiciable, in which case, as lawyers, we haven't done our job. We haven't provided our clients with a contract that has sufficiently settled the relationship between them. This means that after writing the contract, you must be interrogating the contract yourself. You must be thinking, is there anywhere in any of these provisions where I have left ambiguity that could end up costing my client at the end of the day? The second rule to think about is known as the contra proferentum rule. Contra proferentum says that where there is an ambiguity anywhere in a contract, the ambiguity is going to be construed against the interests of whichever party is bringing it forward. So in other words, if one party is relying on ambiguity in a particular provision of the contract, that provision of the contract is going to be construed in favour of the other side in the dispute. Again, this may cost your client significantly. As the drafter, you're the one in the position to make sure that contra proferentum doesn't hurt anybody, because you're the one in the position to make sure that there are no ambiguities in the contract. When you are reading a contract after having written it, when you are proofreading it, look at it with a great deal of care to say, are there ambiguities in my writing? If there are ambiguities in my writing, what can I do to clean them up? Contract writing and will drafting are actually a great deal of fun, and they are a great challenge for people who are interested in high quality legal writing. I've provided extra normal animations for both of these tasks, and I would really encourage you to have a crack. Obviously, given that they're this late in the semester, you're not going to be assessed on these, but why not have a go and stick them up on the Moodle site or email them to me, and I will undertake to give you good feedback to assist you, and then you've obtained a bit of practice at an important legal skill. Well, that brings us to the end of our 12 weeks of advanced statutory interpretation and legal drafting. I hope that this course has been a great deal of use to you in developing what are some basic key legal skills. At the start of the course, I asked the question, what are we doing here? Why is it necessary to do a course on advanced statutory interpretation and legal drafting? And I said that one of the reasons was that the profession is telling us that graduates are leaving universities without sufficient skills in these areas. I hope that in the last 12 weeks, each of you has found something to take away. Each of you has learned something or improved a skill to such a point that you can look at the point that you're at now and say, I recognise that I am now a better legal drafter than I was at the start of the semester. If that's the case, then I'm a happy man and we've had a good term. I do hope you enjoyed this subject, and all the very best for your remaining studies.